Before we begin, a quick and important disclaimer. This content is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. The legal landscape regarding family law, asset division, and matrimonial proceedings varies significantly by jurisdiction and is subject to change. The historical trends and case studies discussed are intended to provide context and should not be used as a substitute for consulting with a qualified attorney or financial professional in your specific state. Viewers are strongly warned to conduct their own due diligence and seek expert counsel before making any decisions related to their legal or financial status. Imagine it is 1926. If you want to end your marriage in the United States, you do not just file paperwork and wait for a cooling-off period. You are entering a battlefield where you must prove a crime. To walk away, you need to provide evidence of adultery, extreme cruelty, or willful desertion. In many states, divorce lawyers in this era are less like the office-bound professionals we see today, and more like gritty film noir detectives. They hire private investigators to peek through keyholes, document clandestine meetings, and gather the physical proof of a matrimonial offense. Without a villain, there is no divorce. Fast forward exactly 1 century to 2026. Today, a divorce lawyer is as much a data scientist and forensic blockchain analyst as they are a legal advocate. Instead of chasing suspects in raincoats, they are deploying artificial intelligence to scan 10,000 emails for hidden offshore accounts and tracing cryptocurrency transfers across decentralized exchanges to ensure a fair split of digital wealth. +1. We are witnessing the most profound transformation of a professional field in American history. This masterclass is designed to help you understand the massive shift in how the U.S. legal system handles the dissolution of the family unit, the potential outcomes of modern litigation, and why the death of the traditional divorce matters to every American taxpayer, homeowner, and parent today. By the end of this deep dive, you will understand how to navigate the high-stakes financial architecture of modern separation, the reality of AI-driven mediation, and the historical trends that have moved us from a system of public shame to one of private, algorithmic settlement. The 1920s through the 1940s represented the era of the legal fiction. Because the law required a specific fault to grant a dissolution, the divorce lawyer's primary job was often to manufacture or discover scandal. This created a bizarre professional duality. On one hand, the lawyer was a pillar of the community. On the other, they were often complicit in collusive divorces where couples would stage a scene of adultery, complete with a hired witness and a photographer, just to meet the strict statutory requirements of the time. This was the age of the Reno divorce. Nevada capitalized on the strict laws of other states by offering a 6-week residency requirement and a more liberal list of faults, turning the divorce lawyer into a travel agent of sorts for the wealthy elite. If you were a middle-class family in 1930, divorce was not just expensive, it was a social death sentence. Only about 1 in 450 marriages ended in divorce during the early 1900s, compared to the nearly 20% of ever-married women who identify as divorced or separated today. The professional change during this first period was characterized by a lack of financial complexity. In 1920, the husband generally controlled the marital assets, and the concept of equitable distribution was virtually non-existent. A lawyer's focus was on securing alimony for a wife who was legally and economically dependent, or defending a husband's estate from a guilty party. There was no such thing as a 401k to split, no stock options to value, and no digital footprints to track. The lawyer was a moral gatekeeper. By the 1960s, the pressure cooker of social change began to crack the foundation of the fault-based system. The landmark shift occurred in 1969 when California, under Governor Ronald Reagan, signed the first no-fault divorce law in the United States. This changed the role of the lawyer overnight. No longer was it necessary to prove who sinned. The new standard was irreconcilable differences. For the legal profession, this was an explosion. Case studies from this era show that when the barrier to entry for divorce dropped, the demand for legal services skyrocketed. Between 1971 and 1981, the number of divorces in some regions tripled. This period introduced the psychological turn in family law. Lawyers began partnering with the burgeoning therapy industry. The professional was no longer just a litigator, they became a crisis manager. However, the most significant change for the U.S. audience was the impact on domestic safety. Historical trends indicate that the introduction of no-fault laws led to a measurable decrease in female suicide rates and a 30% decline in domestic violence, as the legal exit became accessible without the need for a high-stakes, public trial of character. As we moved into the 1980s and 1990s, the profession underwent a financial revolution. This is when the divorce lawyer morphed into a financial architect. As women entered the workforce in record numbers and dual-income households became the norm, the complexity of the marital estate changed the game. Lawyers had to learn how to value businesses, split pensions, and navigate the tax implications of real estate transfers. We saw the rise of the QDRO, Qualified Domestic Relations Order, a specialized legal instrument that allows for the tax-free transfer of retirement funds between spouses. If a lawyer in 1926 saw a modern 2026 property settlement agreement, they wouldn't recognize it. It looks more like a corporate merger document than a family filing. Now let's talk about 2026 because this is where the professional landscape has shifted under your feet. We are currently in the era of the hybrid divorce. The modern divorce lawyer in the US is now managing three distinct technological fronts: AI-powered discovery, virtual mediation, and blockchain forensics. In 2026, the use of AI in document analysis is no longer optional for a top-tier firm. Historical data from the last 5 years shows that manual document review is being phased out. An attorney today uses machine learning to flag inconsistent financial reporting across thousands of pages of bank statements in seconds. For the client, this means a shift in potential outcomes. It is becoming increasingly difficult to hide assets in the digital age. If you bought Bitcoin in 2017 and forgot to mention it in your 2026 disclosure, your spouse's lawyer is likely using blockchain forensics to trace that wallet's history through public ledgers. Furthermore, we are seeing the rise of the gray divorce, the trend of adults over 50 ending long-term marriages. This has created a specialized niche for lawyers who focus on legacy planning and the division of complex, long-term property entanglements. It is less about the who did what of the 1920s and more about the who gets what of the 2020s. The promise of this new era for the US audience is efficiency and transparency, but it comes with a warning. While virtual mediation platforms are reducing costs and allowing busy parents to resolve disputes from their living rooms, the stakes have never been higher. The law is tightening around fees and financial proof. In 2026, reasonable and necessary attorneys' fees are being standardized, meaning you must be more organized than ever. The history of the divorce lawyer is the history of the American family itself, moving from a strict moralistic contract to a complex, data-driven partnership dissolution. In the next parts of this series, we will break down exactly how these historical shifts dictate how you should protect your assets today, the specific traps of modern no-fault systems, and how to use 2026 technology to your advantage, rather than letting it be used against you. This is not just about the law. It is about the evolution of how we value our lives, our labor, and our legacy. A brief history of divorce in America. This resource provides a detailed chronological breakdown of how American divorce laws shifted from the colonial era through the 21st century, offering specific context on the transition from fault-based to no-fault systems. To truly understand why the divorce lawyer of 2026 looks more like a high-end forensic accountant than a courtroom orator, we have to examine the professional pivot that occurred when the law stopped caring about who was a good person and started caring exclusively about where the money was. Imagine it is 1954 in New York City. We will call our client Arthur. Arthur wants to leave his marriage, but in 1954, New York only recognizes one ground for divorce: adultery. If Arthur cannot prove his spouse was unfaithful, he is legally bound to that contract for life, unless he can prove a fraud existed at the time of the wedding. In this era, the divorce lawyer acted as a shadow investigator. They did not spend their time in mediation suites. They spent it in back alleys. Step 1 for a mid-century family lawyer was the retention of a private investigator who specialized in the raid. This was a choreographed legal maneuver where the lawyer, the investigator, and often a hired witness would literally break into a hotel room to catch a spouse in a compromising position. The goal was to produce a photograph or a signed statement from a witness that could withstand the scrutiny of a judge who was looking for any reason to deny the dissolution. Historical trends from the 1940s and 50s show that this created a massive market for staged scenes. Lawyers were often walking a razor-thin line between legal advocacy and suborning perjury. If a couple both wanted to get divorced, they would engage in what was called collusion. The lawyer would essentially script a fake affair. The husband would be caught with a hired model in a hotel, and the court would grant the divorce based on the manufactured evidence. This system was not just messy, it was professionally stagnant. The lawyer's skill set was focused on the theater of morality. They had to be experts in the rules of evidence regarding photography and eyewitness testimony, but they rarely had to touch a spreadsheet. Most marital estates consisted of a single-family home, a car, and a savings account. There was no complexity to be found because the law did not recognize the wife's contribution to the husband's career as a tangible asset. Now, compare Arthur's experience to the professional shift triggered by the Uniform Marriage and Divorce Act and the subsequent 1969 California Revolution. The lawyer's identity shifted from a detective to a negotiator. When the requirement to prove a crime was removed, the volume of cases exploded, leading to what we now recognize as the industrialization of family law. Between 1970 and 1980, the divorce rate in the United States doubled. This was not because more people were unhappy, but because the legal barrier to exiting an unhappy marriage had been lowered. For the legal profession, this meant they had to handle more cases in less time. Imagine if you are a lawyer in 1985. We will call her Sarah. Sarah is representing a client in a high-stakes divorce during the height of the corporate boom. This is the era where the professional landscape changed forever because of the Retirement Equity Act of 1984. Suddenly, Sarah's job was no longer about catching someone in a hotel room. It was about understanding the inner workings of a pension fund. This introduced the Qualified Domestic Relations Order, or QDRO. Before this historical trend took hold, if a husband had a pension, it was his. After 1984, the divorce lawyer had to become a student of federal tax law and actuarial science. Step by step, the 1980s lawyer had to learn a new protocol for discovery. Step 1. Identify all employer-sponsored retirement plans. Step 2. Hire an actuary to determine the present value of a future pension payout. Step 3. Negotiate the percentage of that value that was earned during the marriage. Step 4. Draft a legal instrument that would allow the plan administrator to pay the non-employee spouse directly without triggering a massive tax penalty. This was a radical departure from the 1950s. The lawyer was now a financial strategist. Case studies from the late 80s show that a lawyer's failure to understand these financial instruments often led to massive malpractice suits, further professionalizing the field and forcing lawyers to specialize. You could no longer be a general practitioner who did a few divorces on the side. You had to be a family law specialist. Fast forward to the current landscape of 2026. Let us look at a character named Mark. Mark is a software engineer in Austin, Texas, who is going through a divorce. His lawyer is not looking for hotel receipts. His lawyer is looking for a ghost ledger. In 2026, the modern divorce lawyer utilizes a process called digital discovery that would look like science fiction to the lawyers of the 1980s. The first step in Mark's 2026 divorce is the automated scraping of his digital footprint. The lawyer uses AI-driven software that connects to every financial institution Mark has ever interacted with. This software doesn't just look at balances. It performs a behavioral analysis. It looks for patterns of microtransactions, small transfers of $5 or $10 that occur consistently. These often lead to hidden subscription services, second phones, or clandestine digital wallets. Historical trends in the 2020s showed a massive increase in financial infidelity, where one spouse hides assets in decentralized finance platforms. In 2026, the lawyer's professional toolkit includes specialized subcontractors known as cryptoforensic investigators. If Mark's spouse suspects he has been funneling marital income into a cold wallet, the lawyer initiates a blockchain audit. They track the flow of funds from the known joint checking account to various exchanges, mapping the addresses and timestamps to build a case for a waste of marital assets claim. The complexity doesn't stop at currency. In 2026, we are dealing with the valuation of digital personas. Imagine if Mark's spouse is a successful content creator. The divorce lawyer now has to value a YouTube channel, an Instagram following, and future sponsorship potential. This requires the lawyer to understand algorithmic reach, engagement metrics, and the shelf life of a digital brand. Step by step, the lawyer must 1. Establish the date the brand began to gain traction. 2. Determine what portion of that growth was supported by marital funds or domestic labor. 3. Hire a digital marketing appraiser to project the channel's earnings over the next 5 to 10 years. And 4. Negotiate a buyout or a royalty-sharing agreement. This evolution has turned the divorce lawyer into the CEO of a multidisciplinary team. In the 1920s, the lawyer worked alone. In the 2020s, the lawyer manages a team of forensic accountants, child psychologists, appraisers, and tech experts. The professional changes are also reflected in the billable hour. Historical trends suggest that while the 1950s lawyer might have charged a flat fee for a simple dissolution, the 2026 lawyer is utilizing tiered pricing based on the level of technical discovery required. This deep dive into the professional shift shows us that divorce law in the United States has moved from a battle of morals to a battle of mathematics. The lawyer is no longer there to judge your character. They are there to audit your life. The potential outcomes of a modern divorce are dictated less by the judge's opinion of your lifestyle, and more by the quality of the data your lawyer can extract from the digital ether. But as we look at this century of change, we have to ask, what happens when the math becomes too complex for a human to mediate? What happens when the emotional weight of a century of tradition hits the cold reality of 2026 algorithms? We have explored the shift from detective to data scientist, but we haven't yet touched on the most contentious battlefield of all. As we move into the next part of this series, we are going to look at the dark side of this professional evolution. We will examine the rise of the custody industry, how lawyers and psychologists created a multi-billion-dollar machine to quantify the unquantifiable. We will look at how the 1990s introduction of the best interests of the child standard turned the divorce lawyer into a social engineer, and why, in 2026, your social media history might be more important than your bank account when it comes to keeping your kids. Stay tuned, because the transition from property to people is where the real professional war began. To understand the current state of child custody in 2026, we have to look at the massive professional pivot where the divorce lawyer shifted from a financial liquidator to a social engineer. For the first half of the 20th century, the legal system viewed children through a lens that was almost purely property-based. In the 1920s, if a marriage dissolved, the father often had an absolute right to custody because he was the sole economic provider. Children were viewed as assets that contributed to the household labor or legacy. However, a historical trend known as the tender years doctrine eventually took hold, shifting the preference toward mothers for younger children. For decades, the divorce lawyer's job was simple. If you represented the mother, you emphasized her domesticity. If you represented the father, you looked for evidence of moral unfitness. By the 1990s, the professional landscape underwent a seismic shift with the widespread adoption of the best interests of the child standard. This changed the lawyer's role from a simple advocate to a coordinator of a multidisciplinary team. Imagine a case study from 1994 involving a mother named Linda. In the 1950s, Linda would have likely received custody automatically unless she was proven to be a social pariah. But in 1994, the legal battlefield had changed. To win her case, Linda's lawyer had to hire a forensic psychologist to perform a custodial evaluation. This was the beginning of the custody industry, a multi-billion-dollar machine where lawyers, therapists, and state-appointed advocates began to quantify the emotional bonds of a family. In this era, the divorce lawyer had to master the language of psychology. They weren't just arguing statutes, they were arguing attachment theory and parental alienation. Step by step, a 1990s custody case involved a series of invasive evaluations. Step 1. The appointment of a guardian ad litem, an attorney specifically for the child who acted as the eyes and ears of the court. Step 2. The administration of the MMPI-2, a standardized personality test given to both parents to look for signs of psychopathology or instability. Step 3. Home observations, where a social worker would literally watch a parent interact with their child to grade their parenting skills. This created a new potential outcome for the legal profession, the lawyer as a producer of a psychological narrative. Now, let us bring this into the high-stakes environment of 2026. Today, the divorce lawyer has moved beyond the psychological and into the digital and behavioral. Imagine a character named Jordan. Jordan is a devoted parent in 2026, but he is facing a highly contested custody battle. In the 1920s, Jordan's bank account might have decided his fate. In 1994, his performance on a personality test might have been the key. But in 2026, Jordan's social media history and his IoT digital footprint are the primary witnesses against him. The modern lawyer in 2026 uses a process called sentiment analysis on a client's digital life. Before a single paper is filed, Jordan's lawyer will deploy an AI tool to scan 10 years of Jordan's public and private digital interactions. Why? Because in 2026, the potential outcomes of a custody case are often decided by the digital ghost of a parent's past. If Jordan posted a frustrated comment about his spouse in a private Facebook group 3 years ago, or if his smart home data shows he wasn't home during his scheduled parenting time because his Ring camera didn't detect his face, those data points are now admissible evidence. the divorce lawyer has had to become an expert in the quantified parent. We see this most clearly in the mandatory use of parenting apps like Our Family Wizard or Talking Parents. In 2026, many U.S. courts require high-conflict parents to communicate exclusively through these platforms. This has fundamentally changed the lawyer's daily workflow. Instead of waiting for a client to call with a complaint, the lawyer has real-time access to every text, every calendar update, and every GPS-verified check-in at a custody exchange. Step by step, the lawyer monitors these apps to build a case of micro-compliance or microaggression. If a parent is 3 minutes late for a pickup, the app logs it. If a parent uses a slightly aggressive tone in a message, the AI-powered tone meter flags it for the lawyer to use in the next hearing. Historical trends show that this has led to the professionalization of parenting. The lawyer is no longer just telling you what the law is. They are coaching you on how to perform for the algorithm. They might advise Jordan to engage in specific extracurricular activities with his children, because those activities look better on a 2026 Social Emotional Development Report. They might warn him that his 2022 Venmo history, showing late-night payments at a bar, could be used to paint a picture of an unstable lifestyle. This transition from property to people has made the divorce lawyer one of the most powerful social engineers in the American legal system. They are the ones who draft the parenting plans that dictate exactly where a child will sleep every Tuesday night for the next decade. These plans have grown from simple one-page documents in the 1940s to 50-page technical manuals in 2026, covering everything from the use of wearable technology for children to the specific rules for a child's digital privacy and social media presence. The stakes of this professional change are massive, because the system is now so reliant on expensive experts, the forensic psychologists, the digital investigators, and the parent coordinators. There is a growing divide in the potential outcomes for different socioeconomic classes in the U.S. A wealthy parent in 2026 can afford a lawyer who uses AI to curate their digital image, and a team of experts to testify to their superior parenting. A lower-income parent might be left at the mercy of a state-funded system that uses the same technology, but without the personalized defense. As we look at the trajectory from the 1920s to 2026, we see a profession that has moved from the courtroom to the bedroom, and now to the cloud. The divorce lawyer is the gatekeeper of the modern family structure. They decide who is a fit parent based on a century of evolving social norms and the last 10 years of technological advancements. But there is a new frontier that is starting to disrupt even the most high-tech 2026 law firms. As we have seen, the legal profession has successfully commercialized every aspect of the family unit, from the house to the retirement plan to the child's emotional well-being. But what happens when the very people who built this system, the lawyers themselves, become the targets of a new kind of disruption? In the next part of this masterclass, we are going to look at the Great Consolidation. We will examine how the 2008 financial crisis forced the divorce lawyer to stop being a local counselor and start being a corporate entity. We will look at the rise of the divorce megafirms and how venture capital is now betting on the end of your marriage. If you thought the digital tracking was intense, wait until you see how the business of divorce has been weaponized by the global financial markets. The shift from the solo practitioner to the corporate machine is the next phase of our century-long journey. The transformation from the solo practitioner to the corporate machine began in earnest after the 2008 financial crisis, but by 2026, it has fundamentally rewired the DNA of the legal profession. To understand how we got here, we must first look at the archetype of the mid-century family lawyer. Imagine a professional named Frank in 1975. Frank operates a solo practice on Main Street in a mid-sized American city. His office is filled with physical files, a rotary phone, and a singular secretary who knows the names of every client's children. Frank is a generalist. He handles a real estate closing in the morning, a will in the afternoon, and a divorce trial on Fridays. His reputation is built on local handshakes and a decade of presence in the community. In 1975, the divorce lawyer was a counselor in the most literal sense of the word. The professional change was slow, bound by the geographical limits of how far Frank could drive to a courthouse. Historical trends show that the first crack in this model appeared when the overhead of running a law firm began to outpace the inflation of legal fees. By the late 1990s and early 2000s, the complexity of the financial instruments we discussed in earlier parts, the QDROs, the stock options, the multi-state property holdings, meant that Frank could no longer do it alone. He needed a paralegal who specialized in discovery, and an associate who understood the new tax codes. The solo practitioner was forced to become a small business owner, and the small business owner was soon targeted by the forces of the Great Consolidation. The 2008 economic collapse served as the ultimate catalyst. As middle-class wealth evaporated, the high-volume, low-margin model of legal services became the only way for many firms to survive. This era saw the birth of the legal franchise. Lawyers began to realize that if they could standardize the process of a divorce, creating a repeatable system for intake, filing, and settlement, they could scale across multiple counties and eventually multiple states. The professional role shifted from the craftsman to the manager. Now, let us look at the reality of 2026 through the eyes of a character named Chloe. Chloe is a senior associate at a firm we will call Global Family Solutions. In 2026, Chloe doesn't have a name on a shingle. She has a badge for a corporate high-rise. Her firm is not owned by a group of local partners, but by a private equity group that recognized family law as a recession-proof asset class. This is one of the most significant professional changes in a century. In several U.S. states, including Arizona and Utah, deregulation has allowed non-lawyers to own stakes in law firms, bringing in millions of dollars in venture capital to optimize the business of heartbreak. In this corporate environment, Chloe's day is dictated by KPIs, key performance indicators. Step by step, the corporate divorce machine processes a case with industrial precision. Step 1: the intake. When a potential client clicks an ad on social media, they aren't greeted by a secretary. They are triaged by a sophisticated AI chatbot that performs a conflict check against the firm's massive database and uses natural language processing to determine the complexity of the assets involved. Step 2: the automated discovery. The client is given access to a secure portal where they upload their financial data. Chloe doesn't look at these files yet. Instead, an offshore team of data analysts or an AI auditing tool flags irregularities and prepares a summary report. Step 3: the scripted consultation. Chloe is provided with a data-driven profile of the client before they even speak. She knows their likely emotional state based on their search history and their financial risk profile. Her goal in the meeting is not just legal advice, but conversion and retention. The lawyer in 2026 is trained in sales psychology as much as in the rule of law. Historical trends in the 2020s show that these megafirms have reduced the average time to settlement by 40%, but they have also standardized the potential outcomes. Imagine if you are a client in 2026. You are no longer getting a bespoke legal strategy tailored by a neighbor who knows your history. You are getting the gold, silver, or platinum divorce package. The professional has become a service provider, and the legal advice has been productized into SKUs. If your case fits the standard mold, the corporate machine is incredibly efficient. But if your life is messy, if your business is unconventional, or if your custody needs don't fit the firm's pre-approved templates, the professional change feels like a loss of agency. The entry of private equity into the U.S. legal market has created a phenomenon called the commodification of conflict. Because these firms are beholden to shareholders or investors, there is an inherent pressure to maintain a high volume of cases. This has led to the rise of flat-fee divorce models. While this provides price certainty for the U.S. public, a massive problem in the 1990s and 2000s, it also changes the lawyer's incentive. In 1975, Frank might have fought an extra month to get you that extra 5% of the pension because he cared about his reputation in the town. In 2026, Chloe is incentivized to close your file within the allotted hours defined by the firm's efficiency algorithm. This professional shift has also created a new class of legal workers, the legal technologist. These are individuals who sit between the lawyer and the software, ensuring that the firm's digital infrastructure can handle thousands of simultaneous filings. The divorce lawyer of 2026 spends more time in Zoom-integrated project management software like Clio or Smokeball than they do in a physical courtroom. In fact, many 2026 lawyers rarely see the inside of a courthouse, as the corporate model prioritizes desk-side settlements and digital mediation to keep costs low and turnover high. The impact on the American legal professional is profound. We are seeing a bifurcation of the field. On one side, you have the high-end boutique firms that still offer the Frank-style bespoke service, but at a price point that only the top 1% can afford. On the other side, you have the corporate megafirms that handle the vast majority of American dissolutions through a tech-heavy assembly line process. This is the Great Consolidation. The middle-class family lawyer is disappearing, replaced by the corporate associate. As we move through 2026, this weaponization of the legal business by financial markets has created a system that is faster, more predictable, and more transparent, but also more impersonal. The divorce lawyer has traded their role as a social counselor for a role as a technical administrator in a global financial network. But this corporate efficiency is meeting a sudden and unexpected roadblock. As the public becomes more aware of how the corporate machine operates, a new movement is growing, one that seeks to bypass the lawyers entirely. We have seen the detective become the data scientist, and the counselor become the corporate associate. But there is a silent revolution happening in the shadows of the legal system. In the next part of this deep dive, we are going to explore the rise of the shadow courts. We will look at how the 2026 legal profession is being disrupted by private arbitration and the emergence of non-legal divorce coaches, who are taking over the emotional and strategic roles that lawyers have abandoned. We will examine why the most powerful people in America are now choosing to get divorced in private offices instead of public courtrooms, and how this is creating a two-tiered system of justice that you need to understand to protect your future. The war for the soul of the profession is shifting from the firm to the private forum. The move from the public square to the private forum represents a fundamental fracturing of the American legal tradition. For a century, the local courthouse was the stage where domestic dramas were resolved in the sight of the community. In 1926, the public record was a tool of social control. If you wanted a divorce, you had to air your grievances in a public forum where neighbors, journalists, and even the nosy clerk could see the details of your alleged misconduct. Historical trends show that this publicity served as a deterrent, keeping divorce rates low by leveraging social shame. But by 2026, the professional landscape has inverted. The most successful and sought-after divorce lawyers in the United States are no longer the ones who win in front of a jury. They are the ones who ensure their clients never see the inside of a courtroom at all. This shift has given rise to what we now call the shadow courts. To understand why this is happening, we have to look at the systemic collapse of the public family court system over the last decade. Imagine a character named Elena. Elena is a high-ranking executive in the tech sector in 2026. She is ending a 15-year marriage that involves complex intellectual property assets, venture capital holdings, and a sensitive reputation. If Elena files for divorce in a standard California or New York public court, she is stepping into a system that is still reeling from decades of underfunding and the massive case backlogs that began in the early 2020s. In many major U.S. metropolitan areas, getting a trial date for a complex property division can take upwards of 2 to 3 years. For someone in Elena's position, 3 years of public litigation is not just an emotional drain. It is a financial catastrophe that could devalue her business interests. Her lawyer, a 2026 professional specialized in private adjudication, offers a different path: private arbitration. This is the first tier of the two-tier justice system. In this model, the divorce lawyer's role shifts from a litigator to a contract negotiator. Step by step, the process looks like this. Step 1. Both parties sign a comprehensive arbitration agreement, effectively opting out of the public court's jurisdiction for everything except the final signature on the decree. Step 2. They select and hire their own judge. This is usually a retired high court justice who charges anywhere from $1,000 to $3,000 per hour. Step 3. The entire case is heard in a private law firm's boardroom or a secure, end-to-end encrypted virtual hearing room. For the U.S. public, the potential outcomes of this shadow system are profound. In the public court, a judge might have 50 cases on their docket for a single morning. In the private forum, Elena's hired judge has one case, hers. This allows for a level of forensic detail that is impossible in the public system. The lawyer can spend 8 hours arguing over the valuation of a single patent, without a bailiff telling them to hurry up. This is why the professional change in 2026 has created a specialized class of private judges and arbitration advocates, who operate entirely outside the view of the American taxpayer. But what about the rest of the population? While Elena is in her private boardroom, imagine a character named Marcus. Marcus is a mid-level manager with a standard suburban home and a 401k. He cannot afford a $2,000 an hour private judge. However, he is also facing the same broken public court system. This has led to the second major professional shift of the century: the rise of the divorce coach and the non-legal strategist. Historical trends over the last 10 years show that the billable hour for a traditional attorney has become unsustainable for the average American family. In response, a new profession has emerged to fill the gap between do-it-yourself, online forms and full-scale legal representation. Marcus doesn't hire a law firm to manage his entire case. Instead, he hires a divorce coach, These professionals, often with backgrounds in psychology or finance rather than law, have taken over the roles that lawyers used to perform in the 1970s and 80s, the emotional hand-holding, the strategic planning, and the day-to-day conflict management. In 2026, the professional boundary between a lawyer and a coach is the new legal battlefield. The lawyer is now treated as a technical specialist, someone Marcus hires for just 2 hours to review a final contract or to handle a specific filing. The coach, meanwhile, is the one who helps Marcus use AI-driven tools to organize his financial disclosures and coaches him on how to communicate with his spouse to avoid high-cost litigation. Step by step, the coach guides the client through the pre-legal phase. Step 1. Emotional stabilization and goal setting. Step 2. Document gathering and digital asset mapping. Step 3. Mediation preparation. This has caused a professional crisis for traditional law firms. As coaches and financial neutrals take the easy parts of the case, lawyers are left with only the high-conflict, high-complexity litigation. This is why many 2026 law firms are now white-labeling coaching services, bringing non-lawyer strategists in-house to offer a more holistic and, ironically, more affordable package. The divorce lawyer has had to swallow their pride and acknowledge that for most Americans, a legal degree is not the most important tool for resolving a domestic split. The technology of 2026 has further accelerated this move to the shadows. We are now seeing the emergence of algorithmic mediation. This is a private forum where no humans are present initially. Both parties feed their financial data, their parenting preferences, and their must-haves into a neutral AI platform. The system then runs thousands of simulations to find the point of least resistance, a settlement that maximizes both parties' utility based on historical case data from their specific state. If the parties agree to the AI's suggestion, a lawyer simply reviews the output for statutory compliance and files it. This represents the ultimate professional change. The lawyer, who was once a detective in the 1920s and a financial architect in the 1980s, is becoming a compliance officer for machine-generated settlements. For the U.S. audience, this means that the day in court is becoming a relic of the past. The potential outcomes are more predictable, but they are also increasingly private. However, this two-tiered system, private judges for the wealthy and AI-coached mediation for the middle class, leaves a massive question of equity. When the law is settled in private rooms or through private algorithms, the public legal standards stop evolving. We are losing the transparency that once ensured fairness. Case studies from 2025 and 2026 suggest that as more high-asset cases move into arbitration, the public courts are left only with cases involving poverty, abuse, and state intervention, further stigmatizing the public system. We have documented how the professional has moved from the courthouse to the boardroom and from the law book to the algorithm. We have seen the rise of the coaches who are reclaiming the counselor title from the attorneys. But there is a final, even more disruptive shift occurring. As we have perfected the art of ending marriages, the very definition of what constitutes a marriage is dissolving in the eyes of the law. In the next part of this masterclass, we will dive into the unmarried revolution. We will look at how the 2026 divorce lawyer is now being forced to handle divorces for people who never walked down the aisle. We will examine the rise of cohabitation agreements, the legal war over companion animals, and how the profession is scrambling to define the rights of the millions of Americans who are living in marriage-like relationships without a license. What happens when the divorce lawyer has no marriage contract to break? The answer is redefining the next century of the American legal profession. The professional landscape of the 2020s has been defined by a paradox. While the traditional marriage rate in the United States has reached historical lows, the demand for the skills of the divorce lawyer has never been higher. This is because we have entered the era of the unmarried revolution. In 1926, the legal status of an unmarried couple was non-existent. If you were living together without a license, you were living in sin, and the law offered zero protection for the weaker financial party upon separation. The lawyer's role in these situations was effectively that of a gatekeeper. They would tell you that because there was no contract of marriage, there were no rights to property, support, or inheritance. Historical trends show that the first major crack in this rigid structure occurred in 1976 with the landmark California case of Marvin versus Marvin. This case introduced the concept of palimony to the American lexicon. For the first time, a court recognized that an implied contract could exist between two people who lived together, even without a marriage license. The lawyer's job shifted from simply checking for a certificate to becoming a forensic archaeologist of a relationship. They began searching for evidence of promises made over dinner, shared bank accounts, and domestic services rendered in exchange for financial support. Fast forward to 2026. The professional change has reached its logical conclusion. Today, the modern divorce lawyer is often not doing a divorce at all. They are performing a relationship dissolution for the millions of Americans who have opted out of the state-sanctioned institution of marriage. Case studies from this year show that nearly 25% of 40-year-olds in the U.S. have never been married, yet many of them have lives that are as financially and emotionally entangled as any 1950s nuclear family. Imagine a character named David. David is a project manager in 2026 who has lived with his partner, Sarah, for 15 years. They have a mortgage in both names, a joint investment account for their cryptocurrency, and they have shared the costs of raising Sarah's child from a previous relationship. They never married because they didn't see the point. Now they are breaking up. In 1926, David could have walked away with everything in his name, leaving Sarah with nothing. In 2026, David's lawyer must navigate a complex web of common law, equitable distribution theories, and partition actions that make a standard divorce look simple. The first step for a 2026 lawyer in an unmarried breakup is the contract audit. Because there is no marriage license to provide a default legal framework, the lawyer must look for a cohabitation agreement. If one exists, the lawyer acts as a contract administrator. If one does not exist, which is the case for the majority of U.S. couples, the lawyer must engage in a process called the contribution analysis. This is where the depth of the masterclass really begins. Step by step, the lawyer must prove or disprove a constructive trust. Step 1. The lawyer gathers all digital communication from the last decade to find evidence of a shared intent to own property jointly. Step 2. They perform a forensic audit of all commingled funds. If Sarah paid the utility bills so David could pay down the principal on the mortgage, a 2026 lawyer will argue that Sarah has an equitable lien on the house. Step 3. The lawyer calculates the value of domestic services or business contributions. If Sarah managed David's social media presence, which led to his career advancement, her lawyer will seek a percentage of that increased earning capacity under the theory of quantum merit, the idea that she should be paid what she is worth. This has created a massive professional niche for the breakup lawyer. They are no longer just practitioners of the family code. They are experts in real estate law, contract law, and civil litigation. One of the most contentious and rapidly growing areas of this niche is the legal war over companion animals. In 1926, a dog was property no different from a toaster. If a couple split, whoever bought the dog kept the dog. Historical trends in the 2010s began to challenge this, and by 2026, several U.S. states, including New York and California, have enacted pet custody laws. Now, the lawyer must apply the best interests of the companion animal standard. This is a radical professional change. Imagine David and Sarah fighting over their Labrador. David's lawyer must now build a case based on who has the better relationship with the dog. Step by step, the lawyer will 1. Produce veterinary records to show who took the animal for checkups. 2. Use smart collar data to show who provided more daily exercise. And 3. Present witness testimony from dog trainers or neighbors. The lawyer has had to learn a new vocabulary of canine enrichment and separation anxiety to win in court. Potential outcomes in these cases are no longer just win or lose. In 2026, we are seeing the rise of bird nesting for pets, where the dog stays in the home and the owners rotate in and out, or court-ordered visitation schedules for animals. This professional evolution shows that as the American public's values shift, the lawyer's toolkit must expand to protect what the client values most, even if the law of 1926 would have laughed at the notion. The complexity further deepens with the rise of the digital estate for unmarried couples. In 2026, David and Sarah might share a Netflix account, a high-value gaming profile, or a joint YouTube channel that generates revenue. Because they aren't married, there are no automatic survivorship rights or marital property designations for these digital assets. The lawyer must treat these like a business partnership dissolution. They have to value the digital goodwill of a shared online presence and negotiate the split of followers and future ad revenue. This unmarried revolution has forced the profession to become more proactive. The 2026 lawyer spends significant time drafting pre-cohabitation agreements, the prenup, for people who aren't getting married. These documents are incredibly detailed, covering everything from who gets the frequent flyer miles to who pays for the dog's dental work if they split in 5 years. The professional change is moving from cleaning up the mess to engineering the exit before the relationship even begins. However, this reliance on complex civil litigation instead of the streamlined family court system means that an unmarried breakup in 2026 can actually be more expensive and longer lasting than a traditional divorce. If you don't have the shield of a marriage license, you are in the Wild West of civil court, where the rules of evidence are stricter and the judges are less accustomed to domestic disputes. This is the hidden trap of the modern marriage-free lifestyle that the 2026 lawyer is now tasked with managing. We have seen the lawyer evolve from a moral arbiter to a financial auditor, a social engineer, a corporate associate, and now a civil contract specialist. But even as the lawyer adapts to these new relationship structures, a massive technological wave is threatening to make the human lawyer obsolete. The data-driven world of 2026 has brought us to the edge of a new frontier. In the next part of this series, we will explore the rise of the AI judge and the death of the human advocate. We will look at how 2026 smart contracts are being designed to automatically trigger property divisions and child support payments without a single phone call to a law firm. We will examine the controversial emergence of robo-mediation and why the next generation of American families might trust an algorithm more than a person with the JD. The battle between the human touch and the efficient code is about to begin. The battle between the human touch and the efficient code is not a futuristic concept. It is the daily reality of the legal profession in 2026. To understand the gravity of this shift, we must look at the historical trends of legal decision-making. For nearly a century, the potential outcomes of a divorce were subject to the human element. In 1926, a judge's personal morality or a lawyer's charismatic closing argument could swing the division of an estate by hundreds of thousands of dollars. By the 1980s, we tried to standardize this with child support guidelines and property division statutes, but the human advocate remained the primary engine of the system. However, in 2026, the rise of predictive justice and smart contracts has initiated what many experts call the death of the human advocate as we once knew it. Imagine a character named Emily. Emily is a high-net-worth individual in 2026 who is preparing for a dissolution. In 1996, Emily's lawyer would have spent months researching case law, looking for precedents where a judge ruled in favor of someone in her specific financial position. Today, Emily's lawyer doesn't do research in the traditional sense. Instead, they use a tool called a predictive litigation engine. This AI has ingested every family law ruling in the United States from the last 50 years. Step by step, the lawyer feeds Emily specific variables, years of marriage, tax returns, geographic location, and even the specific judge assigned to the case, into the system. Within seconds, the AI provides a potential outcome with a 94% confidence interval. It tells Emily that based on the judge's history, there is a 72% chance they will award her 55% of the marital home, but only a 12% chance of securing long-term alimony. This professional change has fundamentally altered the lawyer's value proposition. The lawyer is no longer an expert in what the law says. They are becoming a prompt engineer for what the algorithm predicts. Case studies from 2025 show that when both sides have access to the same predictive data, the incentive to litigate vanishes. Why spend $50,000 on a trial when the machine has already shown you the most likely result? This has led to the emergence of the robo-mediator. Imagine if you and your spouse sat down in a virtual room, not with a human mediator, but with an AI specifically programmed to de-escalate conflict. In 2026, these platforms use biometric feedback to manage negotiations. If the AI detects a spike in your heart rate or a change in your vocal frequency that suggests rising anger, it pauses the session. It might say, "Emily, I am sensing increased tension. Let's take a 5-minute break and review the financial neutrality of this proposal." Historical trends indicate that people often find it easier to accept a hard financial truth from a neutral algorithm than from a spouse's lawyer. The AI doesn't have an ego, and it doesn't have a billable hour that increases with the length of the argument. The most radical change, however, is the move toward the self-executing divorce via smart contracts. To understand this, we have to look at the historical trend of the prenuptial agreement. In the 20th century, a prenup was a piece of paper that sat in a safe until it was time to argue about it in court. In 2026, tech-forward couples are using smart prenups built on blockchain technology. These are not just legal documents, they are pieces of code. Imagine a character named Thomas. When Thomas got married in 2023, he and his spouse coded their financial life into a decentralized autonomous organization, or a DAO. Step by step, The smart contract was programmed with specific triggers. Step 1. If a legal filing for dissolution is registered with the state's digital court system, the smart contract automatically pings an oracle to get the current market value of all linked assets, crypto wallets, stock portfolios, and the zestimate of their smart home. Step 2. The contract executes a pre-programmed split. If the agreement says 50-50, the funds are moved into individual wallets instantly. There is no waiting for a court order, no lawyers filing motions to freeze assets, and no risk of one spouse draining the joint account in a fit of rage. The potential outcomes here are a level of efficiency that was unimaginable in 1926. But this efficiency comes with a dark side: the loss of equity. A human judge can look at a case and say the law says X, but in this specific instance of hardship, Y is more just. A smart contract cannot feel empathy. It only knows the code. This is where the 2026 divorce lawyer is finding their new niche as a code auditor. Instead of arguing in front of a jury, the high-level attorney is hired to review the underlying code of a smart contract to ensure there are no backdoors or bugs that could be exploited during a separation. This professional change has created a generational divide in the U.S. legal community. Older attorneys trained in the art of oral advocacy are struggling to stay relevant in a world where the settlement is reached before the first hearing. Meanwhile, a new class of digital native lawyers is emerging. These professionals often have dual degrees in law and computer science. They don't wear suits to a courtroom. They wear headsets to a decentralized virtual mediation space. Historical trends show that as technology makes the process cheaper and faster, the volume of legal actions increases. We are seeing more micro-divorces in 2026. People who were only married for 18 months but have complex digital assets to untangle. Because the cost of a robo-divorce is so low, people are less likely to stay in unhappy situations for financial reasons. The lawyer has moved from being a gatekeeper who prevents divorce to a technician who facilitates a smooth exit. But as we perfect the efficient code, we are running into a new problem. As marriages become easier to end through algorithms, the emotional and psychological fallout remains stubbornly human. We have successfully automated the division of the bank account, but we haven't yet automated the healing of the heart. The 2026 legal profession is now seeing a massive backlash against this cold, algorithmic approach. As we move into the next part of this masterclass, we will explore the rise of the holistic law firm. We will look at how the 2026 lawyer is being forced to integrate mental health professionals and life coaches directly into their practice to survive the AI revolution. We will examine the case studies of firms that are ditching the billable hour in favor of wellness outcomes, and why the most valuable skill for a lawyer in the age of AI might be the one thing a machine can't replicate: radical empathy. Stay tuned, because the human element is about to make a massive, high-stakes comeback. The resurgence of the human element in 2026 is not merely a sentimental reaction to the rise of AI. It is a calculated professional pivot designed to address what researchers call the empathy gap in automated legal systems. To understand this, we must look at the historical trends of the early 2020s, where the market was flooded with low-cost, self-service divorce apps. These tools were excellent at calculating child support or generating property deeds, but they were utterly incapable of managing the acute psychological trauma that often accompanies the dissolution of a family. By 2026, the potential outcomes for many individuals using purely algorithmic systems were technically accurate, but emotionally catastrophic, leading to high rates of post-judgment litigation and parental conflict. Imagine a character named Olivia. Olivia is a specialized healthcare professional in Seattle in 2026. When she first realized her marriage was ending, she tried a high-speed, AI-driven legal platform. It was efficient, yes. It scraped her bank data and produced a settlement in 48 hours. But as Olivia sat in her kitchen looking at the cold, digital PDF, she realized the machine hadn't accounted for her child's specific neurodivergent needs, or the complex guilt she felt about selling a generational family home. The machine could optimize for tax efficiency, but it couldn't optimize for human peace. This is where the modern holistic law firm enters the narrative. Olivia's next step was to hire a 2026 holistic attorney. In this professional model, the lawyer does not act as a solo gladiator. Instead, they lead a multidisciplinary practice that integrates legal, financial, and psychological experts into a single service fee. This is a radical departure from the 1926 model where the lawyer was the only professional involved. Step by step, the holistic process redefines the client experience. Step 1. The emotional intake. Before discussing assets, Olivia meets with an in-house divorce coach who is also a licensed social worker. They map out the emotional flashpoints of the case. Are there safety concerns? Is there a power imbalance? Step 2. The neutral financial evaluation. Instead of each side hiring an expensive expert to fight the other, the firm uses a single neutral forensic accountant to create a transparent financial baseline. Step 3. The interest-based negotiation. Historical trends in the legal field have shown that when people feel heard, they are 60% less likely to return to court for a modification later. The holistic lawyer's value in 2026 is their ability to act as an empathy architect. They use the time saved by AI automated document drafting to engage in deep dive strategy sessions that focus on long-term family stability. For Olivia, this meant the lawyer spent 3 hours mediating a specific parenting plan that included low-sensory transition protocols for her son, a detail no standard algorithm would have prioritized. This professional shift is also a direct response to the great consolidation of the early 2020s. As private equity-backed megafirms commoditized the standard divorce, independent attorneys realized their only competitive advantage was the one thing silicon cannot replicate: nuanced human judgment. We are seeing the rise of the boutique wellness firm. These offices in 2026 look less like mahogany row law libraries and more like high-end wellness centers, complete with meditation rooms and co-parenting workshops. Case studies from 2025 indicate that these firms are seeing record-high client satisfaction rates, even though their fees are often higher than the automated alternatives. Another major component of this 2026 professional change is the death of the billable hour in holistic circles. For a century, the divorce lawyer was incentivized to keep the conflict going, as every phone call and every angry email added to the bill. In 2026, the holistic movement has pioneered the value-based pricing model. The firm charges a flat fee based on the complexity of the family ecosystem, not the time spent fighting. This aligns the lawyer's goals with the client's goals: a fast, peaceful, and durable resolution. If the lawyer resolves the case in 3 months with minimal conflict, they are rewarded with higher profit margins and a happier client. Potential outcomes of this model include a dramatic reduction in what is known as litigation stress syndrome. In the 1980s and 90s, the divorce process was often described as more traumatic than the breakup itself. The 2026 holistic approach seeks to de-lawyer the emotional aspects of the split. The attorney focuses purely on the legal finality, while the support team handles the human transition. Step by step, these firms are building what they call the post-divorce success map. Step 1. Securing the legal decree. Step 2. Helping the client find a new residence and setting up a sustainable budget with a financial planner. Step 3. 6-month follow-up sessions to ensure the parenting plan is working in the real world. The technology of 2026 is actually being repurposed to support this human-centric model. Instead of using AI to replace the lawyer, holistic firms use AI to monitor the health of the settlement. For instance, Olivia's firm uses a sentiment analysis tool on the parenting app communication between her and her ex-spouse. If the AI detects a trend of increasing hostility or a breakdown in cooperation, it triggers an alert to the divorce coach, who reaches out to offer a tune-up mediation session before the situation escalates into a legal battle. This is proactive rather than reactive lawyering. We are witnessing a century-long cycle coming full circle. In 1926, the lawyer was a counselor of morals. In 1986, the lawyer was a financial technician. In 2026, the lawyer is a designer of sustainable futures. This masterclass has documented the professional's journey from the courtroom to the computer, and finally to the consultation room. But even as we celebrate the return of the human touch, a new and formidable challenge is appearing on the horizon, one that ignores borders and traditional jurisdictions entirely. As we have seen, the American divorce lawyer has spent 100 years perfecting the art of the domestic split. But what happens when the marriage was signed in London, the assets are in a Singaporean trust, the children go to school in Switzerland, and the parties live in Florida? The 2026 legal professional is currently facing the final boss of family law, the borderless divorce. In the next part of this deep dive, we are going to explore the rise of the global divorce specialist. We will look at the terrifying complexity of the Hague Convention in the digital age, and how 2026 lawyers are using international treaty loopholes to forum shop for the best possible settlements. We will examine why your location on a GPS map might be the most valuable piece of evidence your lawyer ever collects. The world is getting smaller, but the legal battles are getting much, much bigger. Stay tuned for Part 9 where we go global. To understand the magnitude of the global shift in the legal profession, we must first look back at the extreme isolation of 1926. A century ago, the United States was a collection of legal islands. If a husband fled from New York to New Jersey to avoid a divorce decree, he was often effectively untouchable. The lawyer of that era was limited by the speed of a steam train and the reach of a local sheriff. International divorce was a rarity reserved for the ultra-wealthy elite or European royalty. But in 2026, the domestic family unit has been decentralized. We have entered the era of the global jurisdictional architect, where the most important decision a lawyer makes is not what to argue, but where to argue it. Historical trends show that the first major wave of internationalization occurred in 1980, with the signing of the Hague Convention on the civil aspects of international child abduction. This treaty turned the local divorce lawyer into an international litigator, forced to understand the interplay between U.S. state laws and the legal systems of over 100 signatory nations. However, by 2026, the complexity has scaled exponentially due to the rise of remote work, digital nomadism, and the globalization of personal wealth. Imagine a character named Nicholas. Nicholas is a high-level software architect for a multinational firm. He is an American citizen currently residing in a high-rise in Miami, Florida. His spouse, whom we will call Elena, is a marketing director from the United Kingdom. They were married in Italy, lived in Dubai for 4 years, and own a vacation property in Costa Rica. They have 2 children who hold dual citizenship and attend an international school. When their marriage dissolves in 2026, Nicholas does not just hire a local divorce lawyer, he hires a jurisdictional strategist. The potential outcomes of Nicholas's case will be determined by a high-stakes race to the courthouse known as the first-to-file rule. In 2026, the modern lawyer's first step is a frantic multi-time zone analysis of forum shopping. Step by step, the lawyer must evaluate the pros and cons of each possible jurisdiction. Step 1. The lawyer analyzes the laws of the United Kingdom. London is historically known as the divorce capital of the world because of its tendency to favor the financially weaker spouse with generous, long-term maintenance and an equal split of all assets, regardless of when they were acquired. Step 2. The lawyer analyzes Florida law. Florida might offer Nicholas a more favorable outcome regarding the protection of his premarital tech stock, or a more rigid formula for child support. Step 3. The lawyer checks the residency requirements of Dubai and Italy to see if they offer a strategic advantage or a faster resolution. The professional change here is staggering. In 1926, the lawyer needed to know the local judge. In 2026, Nicholas's lawyer must be an expert in the 2026 Global Family Law Protocol, a digital framework used by major economies to coordinate service of process and asset freezing across borders. If the lawyer is 3 hours late in filing in Miami, and Elena's solicitors file in London first, Nicholas could lose millions of dollars purely based on the geographic location of the paperwork. This has created a new class of networked law firms that maintain 24-hour global operation centers specifically to win the race to the courthouse for international clients. Historical trends also show that as assets become more intangible, they become easier to hide across borders. This brings us to the second pillar of the 2026 global divorce: international forensic asset tracing. In the 1950s, hiding money meant a physical suitcase of cash or a secret local bank account. In 2026, Nicholas might have marital wealth stored in a decentralized autonomous organization, DAO, registered in the Marshall Islands or tied up in non-fungible tokens, NFTs, sitting on a server in Switzerland. The 2026 lawyer utilizes what is known as a global disclosure order. This is a legal instrument that, through international cooperation treaties, forces centralized cryptocurrency exchanges and international banks to freeze assets simultaneously in multiple countries. Step by step, the lawyer's team of digital investigators works as follows. Step 1. Identify the nexus of control, where Nicholas accesses his digital wallets. Step 2. Utilize the Interbank Transparency Act of 2024 to trace the flow of fiat currency into offshore digital exchanges. Step 3. Petition a court in a neutral jurisdiction, such as Singapore, to appoint a digital receiver to take control of the assets before they can be shuffled through a privacy mixer. Case studies from the last 2 years illustrate that the biggest challenge for the 2026 lawyer is the non-signatory state. If Nicholas moves the marital wealth to a country that does not recognize US or UK court orders, the lawyer must become a diplomat. They might engage in comedy litigation, where they argue that the foreign court should recognize the American judgment out of professional respect and the hope for reciprocal treatment in the future. This requires a deep understanding of cultural legal nuances that a 1926 lawyer never had to consider. The human cost of this globalized legal field is most evident in the modern Hague Convention cases. In 2026, parental abduction is no longer just about a parent disappearing with a child. It is about digital abduction and jurisdictional kidnapping. Imagine if Elena takes the children to London for a holiday and then refuses to return them, claiming the UK is now their habitual residence. In 1926, such a case might have languished for years. In 2026, the lawyer uses GPS geofencing data from the children's wearable devices and school attendance records uploaded to the cloud to prove to a judge in real time where the children's life is actually centered. Step by step, the lawyer must file a petition for return within days to prevent a new status quo from being established in the foreign country. Potential outcomes in these high-intensity international cases often hinge on the lawyer's ability to manage a global legal team. The 2026 professional is the lead conductor of a symphony of lawyers in 3 different countries, all billing in different currencies and operating under different rules of evidence. This has led to the executive divorce fee structure, where clients pay a premium for the coordination of these international moving parts. The solo practitioner of 1926 has been replaced by a global project manager with a law degree. As we have documented, the professional change over the last century has moved the divorce lawyer from the town square to the global stage. We have seen the evolution of the lawyer from a detective to a data scientist, a social engineer, a corporate associate, a holistic counselor, and finally, a global jurisdictional strategist. But as the world becomes one giant interconnected legal web, the very foundation of the profession is facing its ultimate test. We have perfected the art of tracking money around the world and fighting for kids across oceans. But as we reach the end of our century-long deep dive, we have to look at the one thing that is starting to make all of this complexity irrelevant. We have seen the rise of the machine and the expansion of the map. But what happens when the next generation of Americans decides that the entire system is too broken to save? In the final part of this masterclass, we are going to explore the future of the end. We will look at the 2027 Great Exit Movement, where couples are choosing private dissolution treaties that bypass every professional we have discussed. We will examine the emergence of the non-legal separation culture and how the divorce lawyer is fighting for survival in a world that is beginning to value social contracts over legal contracts. The final chapter of the century is being written right now, and it might be the end of the divorce lawyer as we know them. The masterclass concludes with the most shocking professional change of all. Stay tuned for part 10. The era of the Great Exit represents the final, most disruptive stage in this century-long transformation. In 1926, the legal system was a fortress designed to keep you inside a marriage, using the divorce lawyer as a high-priced locksmith who only worked for those who could prove a moral crisis. By 2026, that fortress has been bypassed entirely by a new generation of Americans who view the traditional legal system as an obsolete, high-friction relic. We are now seeing the emergence of the relationship design specialist, a professional who has effectively killed the divorce lawyer by making the traditional court-ordered dissolution unnecessary. Historical trends show that whenever a system becomes too complex, too expensive, and too invasive, the public creates a shadow system to replace it. We saw this with the rise of private arbitration in Part 5 and the move to holistic wellness in Part 8. But in 2026, the United States is witnessing a mass migration toward non-legal separation culture. This is not just a trend. It is a fundamental shift in how we define family and property. Case studies from the last 18 months show that a staggering 40% of couples under the age of 35 are opting for private dissolution treaties rather than state-sanctioned marriage licenses. Imagine a character named Maya and her partner Liam. It is 2026, and they are high-earning professionals in the Pacific Northwest. When they decided to build a life together, they didn't go to the county clerk for a marriage license. Instead, they hired a relationship architect. This professional is the final evolution of the divorce lawyer. Their job is not to wait for the marriage to fail. Their job is to engineer the ending before the beginning even starts. Step by step, the relationship architect builds a dynamic domestic treaty. Step 1. The lawyer facilitates a radical transparency audit where Maya and Liam's entire digital and financial lives are mapped onto a private, blockchain encrypted ledger. Step 2. They program a series of conditional triggers. For example, if they decide to have a child, The contract automatically adjusts their equity split in their shared home to account for the career interruption risks of the primary caregiver. Step 3. They establish a self-executing dissolution protocol. The potential outcomes of this model are revolutionary. When Maya and Liam decide to part ways in 2026, there is no frantic call to a litigator. There is no 2-year wait for a judge. Instead, they trigger the exit clause in their digital contract. Because the assets have been tracked and valued in real time for years, the distribution happens instantly. The professional change here is that the lawyer has moved from being a reactive fighter to a proactive systems designer. The lawyer's value is no longer in their ability to argue in a courtroom, but in their ability to code a fair and durable social contract that never needs to see a courtroom. This shift towards social contracts over legal contracts is driven by the realization that the U.S. court system is no longer equipped to handle the speed of modern life. Historical trends indicate that as of 2026, the average contested divorce in a major U.S. city still takes over 18 months to resolve. In a world of instant global communication and high-frequency trading, 18 months is an eternity. The great exit is a rejection of that inefficiency. But what does this mean for the profession? We are seeing the death of the divorce lawyer as a distinct brand. In 2026, the top-tier family law firms are rebranding as life-stage management consultancies. They are merging with estate planners, tax strategists, and even genetic counselors to offer a cradle-to-grave service. The lawyer is no longer an occasional emergency contact. They are a permanent part of a client's professional advisory board, right alongside their accountant and their doctor. Case studies from 2026 show that this has created a new 3-tiered legal reality in the United States. The first tier is the automated tier, low-income families using state-provided AI tools to handle simple, document-heavy dissolutions with zero human intervention. The second tier is the corporate holistic tier, middle-class families using the private equity-backed megafirms we discussed in Part 4. The third tier, and the most influential, is the private treaty tier, the wealthy and the tech-literate who have opted out of the public law entirely, using relationship architects to manage their lives through private code. The most shocking professional change of all is the move toward community-based resolution. As the state's role in marriage weakens, we are seeing the return of circle sentencing and domestic restorative justice. In 2026, some U.S. communities are experimenting with private neighborhood councils that mediate domestic splits based on shared values rather than state statutes. The lawyer's role in these circles is that of a facilitator or an elder, guiding the process through a mix of psychological insight and historical legal wisdom. It is a return to the counselor roots of the 19th century, but powered by 21st century data. Step by step, the 2026 relationship engineer manages these community resolutions. Step 1. The lawyer convenes a neutral support circle of family and financial peers. Step 2. They use AI-generated visualizations to show the long-term impact of different custody and property decisions on the community and the children. Step 3. The parties sign a social peace agreement, which is enforced not by the threat of jail, but by the threat of digital and social exclusion from their private network. Potential outcomes for the next century of the legal profession are clear. The divorce lawyer is becoming a social system architect. They are the ones who will design the protocols for how we live, love, and leave in a world where the state is increasingly irrelevant. The focus has shifted from the law of divorce to the science of separation. We have spent this masterclass documenting a century of change. We have seen the gritty detectives of the 1920s give way to the shark-like litigators of the 1980s, who have now been replaced by the empathetic, tech-integrated strategists of 2026. The professional change is complete. The divorce lawyer did not disappear. They simply evolved into something much more powerful and much more pervasive. They are now the invisible hand that designs the very structure of our personal lives. As we look toward 2030 and beyond, the final question is not how we will get divorced, but how we will choose to be governed in our most intimate moments. The 2026 legal landscape is just the beginning of a new era of personal autonomy. But as the traditional lawyer fades into the background, a new question arises. If we have removed the state from our marriages, and if we have replaced judges with algorithms and private treaties, who is left to protect the vulnerable? The century of the divorce lawyer is over. The century of the relationship architect has begun. But as we close this deep dive, we must acknowledge the one thing that hasn't changed in 100 years. Behind every digital contract, every blockchain ledger, and every AI-mediated settlement, there are still two humans trying to find a way to say goodbye. The technology has changed, the profession has changed, and the world has changed. But the human heart remains the ultimate, unresolvable variable. Thank you for joining this deep dive masterclass. You now hold the keys to understanding a century of professional transformation, from the detective's camera to the architect's code. The future of your family, your finances, and your legacy is no longer in the hands of a judge. It is in the hands of the systems we choose to build today.